Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Every week, our experts discuss your employment rights in Canada. Joining us is employment lawyer John Pincus, partner at employmentlawyer.ca. Before we get to today's questions and phone calls, John, why don't you tell us why it's important that every Canadian knows their employment rights and perhaps talk about a case from this past week?
Well, the workplace is so important to all of us, and I think it's important not only for Canadians to know their employment rights, but to know how those rights operate and how you can enforce them, because often it's a very simple thing that can be resolved without having to go anywhere near a courtroom. And the great thing about the law is the law has a built-in mechanism to prevent people from going to court, and it works almost all the time. And what we're talking about in employment law situations is not about going to court. We're talking about trying to get a practical solution that's going to be something that can work for everyone. And here's a great example of it. Recently, I had someone come across my desk who had been harassed by a very popular person in the office. We all know these situations, they happen. Someone who's very well liked, employer doesn't really want to shake any cages, doesn't want to really bother anyone about it, so they don't investigate it. And they're not investigating it here, even though this person has complained verbally. So what I told this person is, well, the first thing you want to do is you want to complain in writing. You want to complain in writing, and you want to make sure you're very clear exactly what you're complaining about. And if your employer at that stage still refuses to take any action on it, it's at that point you may want to speak to a lawyer, and you want to do it quickly so that we can deal with the situation while it is happening. Now, there may be a situation where you claim constructive dismissal and claim for severance, but often the first thing we're going to try to do is try to make the workplace continue to work. So we might write to them and say, you need to investigate this. You need to take care of it. And often we can help you continue your employment and help the employer treat the situation with the seriousness it deserves.
Okay. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call. John, these calls come to us from your radio shows across Ontario and Canada, where you take calls live from listeners. Let's take a listen to this question.
My mom, she's been working for a pretty large company for 15 years. She's been working Monday to Fridays with the optional Saturdays. She's been fine with that, but they told everyone that they're going to have to start working 2 days a week, 12 hours a day, then off 2 days, then again 12, 12, 12, 3 days in a row, then off. She's not going to know whether she's working on the weekends or not. It's taking a real toll on her health. And as a 51-year-old woman, I'm sure you can imagine that this is like too much.
That seems like a lot.
Right. Well, scheduling changes are a big part of your employment, right? So if you're working the same hours and you've been doing the same hours for a long time, maybe you're working a day shift, maybe you're working a night shift, that can become a fundamental term of your employment. And if your employer changes that, that could be a breach of your employment. And what does that mean? It means it could be a constructive dismissal. So this is a situation that could certainly be constructive dismissal, but I'm not going to say it is for sure, because we have to look at all the circumstances. For instance, is this someone who has accepted scheduling changes throughout their employment? Because if they have, that might be an obstacle to them claiming constructive dismissal. But if they haven't, and this is something important to them, and especially if it's affecting their health and they can get a doctor to substantiate that, it could be constructive dismissal. So let's look at what this person could be owed if it is in fact a constructive dismissal. You're looking at someone who's 51 years old, who's been employed for 15 years in a sales position, 16 months. They could be owed up to 16 months.
Wow.
So if you're looking at compensation at almost $60,000 per year, you can see how much that's going to amount to. That's going to be very, very significant. So you do want to take action. And this is another reason why when these changes happen, you want to act quickly, because otherwise your employer could do it to you again and again and again.
Okay. Great information. Let's take a quick break. And when we come back, employment lawyer John Pincus from employmentlawyer.ca will look at the things your employer is not allowed to do regarding your job. Ask a Lawyer returns in just a moment. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer John Pincus from employmentlawyer.ca is answering questions about your workplace rights. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We'll get to more phone calls and questions in a moment, but first, today's main topic: things your employer is not allowed to do. So let's take a look at 5 key points under that umbrella. First, your employer can't make significant changes to your job.
Right, this is what we call a constructive dismissal. If your employer makes significant changes to your job and you don't agree to those changes, then that is what we call a situation where you can claim for your severance. It's called a constructive dismissal, and you get the same severance entitlements as everyone else. Well, what are we talking about? Of course, the classic one, the demotion, right? The drop in pay, change in hours, a change in location. And we're often talking about questions of degree, so you can't really make these decisions on your own. You really have to speak with an employment lawyer. But if it is a constructive dismissal, you're going to be entitled to severance. So the place you may want to start is the Pocket Employment Lawyer, where we list a bunch of areas where it could be constructive dismissal. And you can also find out there what your severance entitlements might be by using the free and anonymous severance pay calculator.
Okay, next one. Your employer can't put you on probation after you pass the initial probationary period.
Right. If you are in a probationary period, it has to be something that is put into contract. If it's not in a contract, there's no kind of standard probationary period. There's no such thing as a legal probationary period under the law. It's a contractual issue. So if you are working and they say after the fact, we're going to impose a probationary period, or we're going to impose a new probationary period, that could be a breach of your contract. And the other thing, this is very important, they could be preparing to let you go. So you want to object to it and object to it in writing to make it clear that you're not agreeing to that.
Okay, number 3 on the list of things your employer can't do. They can't refuse to pay you overtime if you have already worked those extra hours.
Right. This is a huge misconception. They say, well, we didn't authorize those overtime hours, so we don't have to pay it. No. If you're an employer and you didn't authorize overtime hours, the remedy is you can discipline that employee. You can discipline that employee for basically being insubordinate, not listening to you when you told them not to work overtime hours, but you still have to pay it. And if you are constantly working overtime hours and your employer is not paying it, you could be owed unpaid wages, and it could in some circumstances even be a constructive dismissal.
Okay. Next one. Things your employer can't do. Make up a bogus negative performance review.
Well, they certainly do this. They do this a lot. And when they do this, you need to make sure that you respond. And I always tell people, be fair about it. Say, you know what, these areas you're right about, and I'm going to respond this way. These areas are unfair, and here's why they're unfair. And the reason why it's so important to do this and not just sign on the dotted line is because if your employer is giving you a performance improvement plan, 90% of the time, it's not so you can improve. It's because they are waiting to let you go, and they want to be able to justify that decision to let you go. So you need to be prepared to make sure your voice is heard in that process.
Okay, last on our list of things that your employer can't do. Take away your seniority by making you an independent contractor.
Right. And we really have to think for a second about the logic of this, right? You're an employee one day and all of a sudden the next day you're an independent contractor because you've signed an agreement saying you are? No, of course not. If you are hired as an employee, you are an employee. And simply by the employer labeling you as an independent contractor, even if you're submitting invoices and charging HST, that might be a tax problem. But as far as employment law is concerned, you are still going to be an employee if you are still effectively working for someone else. So that's a situation where if your employer makes you an independent contractor, you still have your rights. And you probably shouldn't be signing that agreement.
Okay. Great advice. Great advice, John. Okay, so let's listen to another phone call from one of your live radio shows. Take a listen.
I've worked for a company for 10 years. I'm 61. I'm a server. We were given written working notice. We will no longer be employed. I was just wondering if I'm entitled to severance, or am I working for my severance now?
Right. We always talk about why it doesn't matter if it's a big employer or a small employer. This is one of those situations where it actually does matter to a limited extent. If someone is a very small employer and their payroll is under $2.5 million, they can actually provide you all of your severance by way of working notice. Now, you may still be owed severance at the end of that working notice period, so you definitely want to speak to a lawyer about that. But if you leave before that working notice is over, that is a resignation and you lose the rest of your severance. So unless you have another job offer and you're prepared to, get rid of all the other severance that you may be owed, you want to stick around until that end of that working notice period.
Okay, John, that's, again, great advice. Let's take a short break, and when we come back, we'll examine the consequences of making a mistake on the job and more. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. John Pincus from employmentlawyer.ca is taking questions about your workplace rights. If you want to get in touch with John and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots more to get to, including this call that came into your radio show recently. Take a listen.
My sister-in-law, she works for a fairly large bank. She's been there for 18 years. They emailed her to say she was invited to a meeting, and it was to let her go. And there were 4 others that were let go, and they didn't offer them positions anywhere else. And she's an excellent employee, and I'm not saying that because she's my sister-in-law, but she was in shock, absolute shock.
I've heard of this before, that general email to a meeting. It's harsh.
It's harsh, and it really hits you, and it's a very emotional thing. It's a very emotional thing, particularly for people who've been there for a long time. But the reality is, as we talk about sometimes in this show, your employer can let you go for almost any reason. Now, the interesting thing about federally regulated employees is there are certain employees in certain circumstances who can actually seek reinstatement. But generally speaking, what we're talking about when we're talking about someone who's been let go and what are their rights, the rights are to get paid severance. Your employer can let you go as long as they pay you the proper severance. And once they terminate you without cause, which is typically the kind of termination we're talking about, they actually don't need to prove that you were a bad employee. You could be the best employee. You could be employee of the year. You could be employee of the decade. They're still allowed to let you go. They just have to pay the proper severance. So let's take a look at the severance pay calculator and see what this person is entitled to. And this is, again, a tool I really, really recommend people use. You can find it on pocketemploymentlawyer.ca. It's free. It's anonymous. And if this person were to go on pocketemploymentlawyer.ca, this is what they would find. You're 56 years old, you're a bank supervisor, you've been there for 18 years, earning $82,000. Up to 2 years' pay this person could be owed, right? So they're not necessarily going to be entitled to their job back. They're not necessarily going to be entitled to another job. In fact, in many circumstances, in most circumstances, you will not be. But a significant severance package, potentially as much as $164,000, right? So this is definitely a situation you want to be speaking to an employment lawyer.
Right, that's a lot of money to leave behind.
It is a lot of money to leave behind, right? So it's the silver lining here, right? Can you get your job back? Probably not, even if you're federally regulated. But you are still entitled to a severance package. You still have rights.
Okay, time for another question. This one from your live streams on Facebook and YouTube, which people can find by going to stlawyers.ca. I worked for 4 years at an auto body shop, earning constant positive feedback from customers. When I made one minor mistake on a client's vehicle, I was fired right on the spot. My boss said it was for cause. Did he make the right call? What do you think?
No, certainly not. And this is probably the perfect example that one could think of as what is not just cause under the law, right? You work for 4 years, you generally speaking do good work, even if it wasn't great work, but satisfactory work. All of a sudden you make a mistake and you're terminated for cause. No, the law will still obligate the company to pay severance here. And in fact, the company could be in trouble for not paying them anything in these circumstances. Mistakes do not justify what we call the capital punishment of employment law. It has to be sustained, really, really serious poor performance levels over a period of time with warnings, usually with suspension, and even then sometimes that is not enough to be just cause for dismissal. Typically just cause for dismissal is not reserved for performance issues. Typically it's more reserved for issues of dishonesty or fraud, something where you are clearly doing something that is totally inconsistent with your obligations as an employee, and this is just not it.
And fired on the spot, are there any ramifications to that at all, or not really in the law?
Anyone can be fired on the spot, and as we say, you can be fired for almost any reason. They don't have to give you notice if they pay you in lieu of that notice, but they have to pay the proper severance package, and that's the problem here is there's no severance being offered. That's a breach of employment standards, and it's a breach of that person's full entitlements.
Okay, so let's take a quick pause, and then when we return with John Pincus, partner at employmentlawyer.ca, we'll see what happens if you keep working after your contract ends, and does a new owner have to honor your past seniority? The answers to those questions are next on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from employmentlawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. John Pincus from employmentlawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's take a look at another situation that your firm has come across. My 3-year contract expired a few months ago. However, my employer kept me on until last week when he fired me. When I asked if I could get 2 weeks' pay, he said my contract declared that I wouldn't get a penny after it ended. Are those contracts ironclad? Great question.
Right, and there's actually an understandable misconception on the part of the employer here, because typically when we're talking about a fixed-term contract, your notice is the contract itself. You work until the end of the contract and you know that it is coming to an end, so you don't have to get 2 weeks' notice. But in this case, the contract already expired a few months ago. So because it expired a few months ago, that contract no longer applies, and that person is an indefinite employee with all their years of service relevant to their severance entitlements. So this is a person that can go on the Pocket Employment Lawyer, that can go on the severance pay calculator, and can find out exactly how much they're owed. And they don't have to do anything special for the fact that they were on a fixed-term contract, because that fixed-term contract is now irrelevant. Very important thing that we need to think about when you're talking about fixed-term contracts, especially people who are on successive fixed-term contracts. If you're on a fixed-term contract again and again and again, you also could be an indefinite employee. So it doesn't mean that just because you're on a fixed-term contract that you don't have an entitlement to severance. The other thing, very important for people to know, if you are on a fixed-term contract and your employment and your contract is terminated early, then you could actually be entitled to the balance. So you could be someone on a 3-year fixed-term contract. If you are let go at the end of year 1, depending on what is in that contract, you could actually be entitled to the remaining 2 years' pay, even though you've been there for 1 year. So a very important thing to consider for employees, and also a very important thing to consider for employers when you're preparing these contracts.
Time for another scenario that your team has recently handled. I was with an IT company for 6 years when it was sold to new owners. 1 year later, I was offered a lower position with less responsibilities. When I declined, I was fired with 1 week's pay. Is that enough?
No, it's not enough. In fact, I would say that's grossly insufficient. It's not only insufficient for that person's full entitlements, it's actually insufficient for that person's minimum entitlements under the Employment Standards Act. What the Employment Standards Act says is if there is a purchase of a business and you maintain your employment, then that new employer, the purchaser, has to treat your employment as continuous. So this person under the Employment Standards Act is a 7-year employee. The other thing here is that when we are looking at your employment after a purchase and sale, we are looking at the totality of your employment. We're looking at your full tenure. Consideration has to be given to the tenure that you had prior to the purchase and sale. So even if we're looking at your full entitlements, we're going to be looking at more than a week's pay. We're going to be looking at more than a month's pay because that employer has the benefit of the previous service. So there's a lot wrong going on there.
So let me ask you this. What if the company you work for, business you work for, albeit 5 years, 6 years, maybe even 10 years, gets sold and you don't want to work for the new employer? What do you do then?
Well, in that case, you have to think about whether the choice is reasonable. Are you being offered pretty much the same job with pretty much the same compensation, or are you being offered a totally different job? If you don't accept the job for a good reason, you may actually be entitled to your full severance. But if you don't accept the job and it was a comparable job, then you may only be entitled to your minimum severance entitlements. That's going to be a lot less. So you want to really think about that, and you may want to speak to an employment lawyer to make sure that you're making the right choice, so that if you are going to get a lot less severance, you're at least doing it with your eyes open.
Right, you have to weigh your pros and cons. Do you want to stay employed? Do you want to take that less severance package? There's a lot to think about. There's always a lot to think about, John, when we're talking about various scenarios in employment law. So thank you so much for being here today and providing so much wisdom and so much great advice. You can catch legal experts from employmentlawyer.ca right here on Ask a Lawyer every Wednesday on CP24. For more information on this show and employmentlawyer.ca, visit cp24.com/askalawyer. Join us next week as we examine maternity leave and employee rights. Thanks for watching. See you then.